Imagine waking up on a crisp Saturday morning, the kind of morning where you expect nothing but peace and the sound of birds chirping. You walk to your kitchen, pour a fresh cup of coffee, and look out the window at the backyard you've spent years maintaining. But instead of your prize-winning flower beds and the open green space you paid for, you see something that makes your blood run cold. There is a full construction crew, 3 trucks, and a mountain of lumber sitting directly on your grass. And standing right in the center of it all, acting like a general on a battlefield, is your neighbor, Sarah. Sarah has lived next door for 3 years, and in that time, she has earned a reputation for being the neighborhood's most difficult resident. She is the type of person who measures the height of everyone's grass with a ruler and calls the city if a trash can is left out for an extra hour. But today, she wasn't just complaining. Today, she was launching a full-scale invasion of your property. As you walk outside, still in your robe, you ask the foreman of the crew what they are doing. He looks at a clipboard and then points to a line of stakes driven deep into your lawn, at least 6 feet past the actual property line. He tells you they are installing a premium, 8-foot-tall privacy fence. When you tell him that he's standing on your land, Sarah marches over with a smirk that can only be described as pure entitlement. She doesn't apologize. She doesn't explain. Instead, she looks you in the eye and tells you that she had a vision for her backyard, and according to her internal sense of the map, this land was always hers. She claims the previous owners of your house had a handshake deal with her, granting her this extra space. You know for a fact that this is a lie. Your deed is clear, your survey is official, and there is no such thing as a handshake deal that overrides a legal land title in the United States. You try to remain calm, but Sarah begins to raise her voice, attracting the attention of other neighbors who are now coming out onto their porches to watch the drama unfold. She starts accusing you of being aggressive and tells the construction crew to keep working, promising them that she will take full responsibility. This is a critical moment. In the world of property disputes, how you react in these first few minutes can change the outcome of a court case. Mark, the homeowner, realized this instantly. He stopped arguing, went back inside, and pulled out his phone. He didn't just call the police. He started documenting everything. He took high-resolution photos of the workers, the materials, and most importantly, Sarah's face as she shouted commands. He then called his attorney, a man who specialized in real estate law, who gave him a very specific piece of advice. Do not touch their equipment, and do not threaten them. Let them build it. The bigger they build, the harder they fall. Over the next 48 hours, the transformation was staggering. Sarah didn't just build a simple fence. She built a fortress. It was high-grade cedar, reinforced with steel posts, and it looked like it cost a fortune. She even had the crew install expensive outdoor lighting along the top of the fence, all of which was being powered by an extension cord she had tried to hide under the grass. By Monday morning, Mark's beautiful, open backyard had been sliced open. His expensive rose bushes were crushed under the weight of the lumber, and his view of the sunset was replaced by a wall of wood. Sarah was seen on her new, extended patio, sipping wine and celebrating her victory. She truly believed that once a structure was built, it became a permanent part of the landscape, a concept she misinterpreted from a half-read article about adverse possession. But while Sarah was celebrating, Mark was working. He hired a licensed land surveyor to come out immediately. In the U.S., a certified survey is like a golden ticket in court. It is a scientific, legal document that no handshake deal can beat. The surveyor spent 4 hours measuring, using GPS coordinates that were accurate down to the millimeter. The result was undeniable. The fence was 6 feet and 2 inches inside Mark's property line along the entire length of the yard. That afternoon, Mark's lawyer drafted a formal notice of encroachment and a cease and desist. This wasn't just a polite letter. It was a legal warning that Sarah was currently committing civil trespass. When the process server handed the envelope to Sarah, she didn't even open it. She laughed, tore it into pieces, and let the wind carry the scraps onto Mark's driveway. She thought she was untouchable. The lawsuit was filed 3 days later in the county superior court. Mark sued for trespassing, encroachment, and property damage. He also sued for injunctive relief, which is a fancy legal term asking the judge to force Sarah to remove the fence immediately. In many states, if someone builds a structure on your land, you cannot simply tear it down yourself without a court order, or you might be liable for damaging their property. Mark was playing the long game, following every rule to ensure he would win. When the day of the hearing arrived, the contrast between the two parties was sharp. Mark arrived with his lawyer, a thick binder of evidence, and the certified surveyor as an expert witness. Sarah showed up alone, carrying a stack of blurry photos and a handwritten note she claimed was from the previous owner, though the signature looked suspiciously like her own handwriting. The judge, a no-nonsense woman with 20 years on the bench, looked at Mark's survey for exactly 30 seconds before nodding. Then she turned to Sarah. Sarah began a long, rambling speech about how Mark's house was too big and how she deserved the land because she was the one who actually cared for the neighborhood. She talked about her vision and her rights as a taxpayer. The judge interrupted her and asked one simple question. Do you have a certified survey that contradicts the one provided by the plaintiff? Sarah froze. She tried to say that surveys are just opinions, but the judge slammed her gavel down. In the eyes of the law, land titles are not opinions. They are facts. The judge's ruling was swifter and more brutal than anyone expected. She didn't just order Sarah to move the fence. She declared that Sarah had acted with willful and wanton disregard for the law. This is a key phrase because it opens the door for punitive damages. The judge ordered that the fence be removed within 72 hours. If Sarah didn't do it, Mark was authorized to hire his own crew to tear it down, and Sarah would be forced to pay the bill. Furthermore, Sarah was ordered to pay for the full restoration of Mark's landscaping, including the replacement of his mature rose bushes, which were valued at $3,000. But the biggest blow was yet to come. Because Sarah had ignored the initial cease and desist and had been so hostile, the judge ordered her to pay Mark's legal fees in full. By the time the numbers were added up, the cost of Sarah's vision was staggering. The fence itself had cost her $12,000 to build. The removal crew cost another $4,000. The landscaping restoration was $3,000. And Mark's legal fees, which had grown throughout the litigation, were nearly $20,000. Sarah was looking at a total bill of nearly $40,000 for a piece of land that was never hers to begin with. The most satisfying part for the neighborhood happened on a Tuesday morning. The same construction crew that had built the fence arrived to take it down. Sarah had to stand on her porch and watch as they used chainsaws to cut her beautiful cedar fortress into pieces. Because the wood had been cut and drilled, it was useless for a new fence. It was loaded into a dumpster and hauled away to a landfill. This story serves as a massive warning to anyone dealing with an entitled neighbor or a Karen who thinks they are above the law. In the United States, property rights are the foundation of civil society. You cannot simply claim what isn't yours because you feel like you deserve it. Mark's patience and his reliance on the legal system turned a frustrating situation into a total victory. He got his land back, his garden was replanted better than before, and Sarah was so financially drained by the lawsuit that she ended up putting her house on the market and moving away just 6 months later. The neighborhood finally returned to the peace it had before she arrived. If you ever find yourself in a situation like this, remember, don't shout, don't threaten, and don't take the law into your own hands. Get a survey, get a lawyer, and let the court do the heavy lifting for you. The law may move slowly, but when it lands with the weight of a mountain.